Looks like everyone is ready. I'd like to do a quick sound check for Justice Apple. I believe Chandler Surrency is the appellee. Is that correct?
Yes, good morning, Your Honor.
Can you hear Justice Apple? Thank you.
I can
Okay,
hear just fine.
thank you.
Thank you.
And Siobhan Briley, if you'd do a quick sound check, and then when you're ready, you can begin.
Is that, there we go. Sound check by Siobhan Briley.
Thank you very much. I can hear you well.
Great.
You may proceed. Thank you.
Madam Chief Justice, and may it please the court, counsel, good morning. This case of first impression presents two primary questions. First, if Section 633.637 of the probate code is not complied with in the first instance, what can be done and when? And second, who can challenge the failure to comply with 633.637? There's no argument that failure to comply with this section of the probate code can be challenged in court. So the fighting issues in this case are when can it be challenged and who can raise that challenge. The Keeneys submit that a challenge can be raised at any time after a protected person, a person under a guardianship, has made a will without complying with the requirement in 633.637 that a determination of that person's testamentary capacity
Counsel?
be made. Yes,
Is
Your
it your
Honor.
position that the statute actually requires a court determination at the time the will is made?
It is the Keeney's position, Your Honor, that the court must make that determination at the time the will is made. The reason for that is, first, the protected person may not make the will unless the determination is made. If the court does not make that determination, then there's no guidance as to who can make that determination. So the two parts of that are, yes, the court must make that determination, and yes, that determination must be made before the will is executed or,
So
immediately before.
what do you make of the language then from the statute that says that a ward shall not have the power to convey property in any manner other than by will if the ward possesses the requisite testamentary capacity, unless the court determines that the ward has a limited ability to handle the ward's own funds? You think that that subsequent phrase, unless the court determines that the ward has a limited ability to handle the ward's own funds, apply to both current dispositions as well as the making of a will?
No, Your Honor. The provision that the court can make this limited determination about the ward's ability to handle funds applies only to the present ability to handle funds. The determination regarding testamentary capacity specifically modifies making a will. That is a requirement for a protected person to make a will.
Okay, but agreed. But it doesn't say that that decision has to be made at the time. It just says other than by will if the ward possesses the requisite testamentary capacity. Isn't that true of any will?
That is correct. That is true of any will. However, with wills that are executed by persons not subject to conservatorships, it is assumed that those persons have testamentary capacity. The code indicates that any person of full age and sound mind can, has the capacity to execute a will.
Right, so now we're just talking about presumptions. And I think you'll probably get to that when you're talking about when that decision can be made, but that seems to me to be contrary to the statute to say that it requires the court to make that determination at the time that the will is made.
One of the issues in this case is that the statute provides very little, if any, clear guidance about how this provision is to be administered. So absent a determination by a court of law that the person executing the will, the person subject to the conservatorship who's executing the will, has testamentary capacity, it is not clear in any way how that determination should be made. Is the determination left to the fiduciary? That seems to open the ward up to significant manipulation and potential abuse. My reading of the statute does not lead to the conclusion. I don't read the statute to say that the conservator has the power to make that determination. And that is supported also by sections, I believe it is
Counsel,
643. Yes, Your Honor.
With respect to 633, 637, do you agree that the finding of limited ability to handle one's own funds is not necessarily the same as testamentary capacity or lack thereof?
Yes, Your Honor, I do agree with that.
So if that statute says the court has to make that finding specifically, what statute do you point to that says the district court must make a finding of testamentary capacity? Because it seems like it explicitly says that doesn't need to be done, right? I mean, it's a totally different inquiry under the statute.
I'm not sure if I understand all of the parts of your question.
Well,
Justice
let me ask it this way. That statute does not state the district court must make a finding of testamentary capacity. Would you agree with that?
I do agree with that, Your Honor.
So what statute can you point us to that does require the district court to make such a finding?
And herein lies the problem with this particular provision. We do not have a statute to point to that says when you are dealing with 633.637, go to this other statute to determine how this determination must be made. Our position is that it must be the court's determination, in part because sections 633.643 and 6.645 require that the will be deposited with the clerk of the court and then with the court itself.
Let me raise another issue that occurs to me, Ms. Briley. Our rule is that testamentary capacity is an issue that is tried to a jury, correct?
Correct, Your Honor.
And I think that reflects sort of the feeling that these kinds of will contests that arise after the fact are things that ought to be decided by a jury of one's peers. They ought to reflect sort of the conscience of the community and not the determination of a single judge. Under what you're talking about, you would have a single judge determination, wouldn't you?
Excuse me, not necessarily. I mean, there is, again, no specific guidance as to.
So in the conservatorship proceeding, you would have a jury trial inside you, is that what you're thinking?
No, Your Honor. And to be honest, in terms of how a determination, a court proceeding, whether it's a jury trial or a bench trial would, occur, is, frankly, I hadn't gone down that far down the road because, again, the guidance regarding how to comply with this provision is so scant.
Is another, my take on it is it's scant because the legislature did not intend to have pre-death challenges to wills. I'm not sure it makes sense. Here we have a will in 1992 and another one in 2015. What if he does another one in 2021? Why don't we just wait until the protected person has died and the will is probated, and then all parties with an interest in inheriting, in challenging or defending the will can be brought into one proceeding with a jury to decide factual questions. Doesn't that make more sense?
With all due respect, no, Justice Waterman, that does not make more sense. We have a number of problems if that is the interpretation of this particular provision of the probate code. One of the biggest problems is the longer it is weighted, to use the subjective. The more people's memories are compromised, the less likely it is there will be competent evidence regarding that person's competency. And this is why in will contests where the will is presumed to be executed by a person with testamentary capacity, it is the contestant's burden to show lack of testamentary capacity. Here, as Justice Oxley, raised earlier, the question is, when you have a presumption of lack of testamentary capacity, which, again, there's not a significant amount of guidance, but we do have, one unreported Iowa case that has addressed this, and in that case,
Counsel,
yes.
under your view, who has standing to challenge this pre-death?
That's a very good question, Your Honor, and this is, and in fact, I think even more of a key question here. Again, there is no specific statement about who has standing to raise this challenge. The code suggests that it could be someone who could have an interest in the potential estate after the ward's death, interpretation of subsection 122 regarding challenging fiduciary activities, or it could be narrowly confined, like challenges, like will contests are. You can look at definitions of interested persons in the probate code. Those don't actually provide any guidance.
So what if you had a hypothetical where a neighbor, before a ward was to, a guardianship and conservatorship was established, and then you have a will made after it's established, and then a neighbor says, well, before this was established, Mr. X or Mr. such and such told me I was going to inherit when he died. So does the neighbor have standing to pursue a pre-death testamentary challenge under that fact pattern?
I would say no, Your Honor, because that particular hypothetical is a pretty extreme example of who might raise such a challenge. As we know, it's not an easy thing to...
What if the neighbor was written into the prior will made before the conservatorship was established?
If the neighbor was written into the prior will before the conservatorship was established and no determination regarding the ward's testamentary capacity was made after the conservatorship was established and before the ward made the new will, then yes, the neighbor would have standing because the neighbor was named in the prior will. And under the most narrow definition of interested person, the neighbor would have standing to challenge a will.
How do you distinguish the Burkhofer case where we said somebody who has an interest in a potential estate is too contingent to constitute a legal interest sufficient to establish standing?
In that case, if my recollection serves me, that was specifically regarding will contests. And in a will contest, it makes sense to limit the interested persons to those with an immediate interest in the estate. Otherwise, the proceeding can get too complicated, too far afield of what's actually in the document. One particular distinction that is important in that context is that when you have a will contest, the contents of the will are already known. The people contesting the will are contesting the information they know. This situation of challenging the lack of determination of testamentary capacity is not actually challenging the contents of the will. It's challenging a person's ability to make a determination.
Are these will, I couldn't find them in the record. Are they not in the record?
No, Your Honor, they are not in the record. They were deposited with the court, but not released, at least to the Keeneys, because the testator is still living and it is, protected attorney-client material.
Whether they were self-proving?
No, we have not even progressed to testimony at this point. This is, the appeal of a decision, a reconsideration on a motion to dismiss.
Or maybe not testimony is the correct word, but any affidavits or anything attached to the initial documents that they were self-proving or not?
Not that I am aware of. None of that has been, I have not been able to find it. The inquiries that were made did not turn up any such documentation.
Counsel, is there any similar situation that you know of where we permit parties to contest wills pre-death?
There's a similar situation in which parties are able to contest testamentary documents pre-death, and that is in the context of trusts. And that would be the In re, and if I mispronounced it, I apologize, Dreesen case. And that makes sense because the person's testamentary intent can be established because that person is still living and can actually contribute to that. And for that reason, the trust code contains a much broader definition of interested person than does the probate code, and specifically states that the definition, should be flexible to address the situations as they arise.
Nikki, you may wrap up.
Thank you. The Keens respectfully request that this court reverse the district court's granting of the motion to enlarge and dismissing on the motion to dismiss. Thank you.
Thank you.
Ask one question. Could you repeat that case name for me, Ms. Briley? Did you say Dreesen?
Yes, and
Okay,
I
thank
can
you.
spell that for you. It's Driesen, In re Guardianship of Dreesen, 771 Northwest 2nd, 652. Thank you.
Ms. Surrency, when you're ready.
May it please the court, counsel. My name is Chandler Surrency, and I represent Washington State Bank as conservator for Vernon Radda. As you know, this case involves the guardianship and conservatorship of Vernon Radda. And as the court is well aware, the purpose of a guardianship and conservatorship is to do what is in the best interest of the ward.
If you choose, you can take your mask down.
I prefer to keep it on if that's all right.
Absolutely.
Thank you, Your Honor. Mr. Radda's interests must remain at the forefront of this litigation. This appeal involves an order enlarging a ruling on a motion to dismiss. That order had 3 sections. The first was that stated that this action may only proceed for a determination of whether Mr. Radda currently has the capacity to execute a will. Second, whether a determination of whether Mr. Radda had capacity to execute prior wills can only be made after his death. And third, petitioners will be responsible for the costs of this action. Central to this matter is Iowa Code Section 633, 637. Justice Oxley, we went through the specific wording of that statute, but I want to return to that just briefly. The statute states, "A ward for whom a conservator has been appointed shall not have the power to convey, encumber, or dispose of property in any manner other than by will if the ward possesses the requisite testamentary capacity, unless the court determines that the ward has a limited ability to handle the ward's own funds." As with all statutes, we must attempt to interpret this code section as the legislature
Counsel.
intended. Yes.
On that point, the district court ruling quotes Ward v. State from 1956. And the quote that the district court provides says, "The fact of guardianship is presumptive proof of incompetency to make a will, and the burden is on the proponent to overcome such presumption." What's this court supposed to make of that line?
Well, Your Honor, I think that rather than focusing on Ward versus State, in the matter of a State versus Springer was a 1961 case from this court. And in that case, there was a voluntary guardianship in place, which is actually the case here. Mr. Radda agreed to have this guardianship and conservatorship put into place. So in the Springer case, it actually involved a will contest after the death of the testator, but in that case, they said the fact that decedent was under guardianship does not in this case raise a presumption of incompetency and make a case for the jury on that ground alone as contended by contestants. This was a voluntary guardianship under section 670.5, and no presumption is raised.
Other than how a guardianship is set up, there's a different way of doing voluntary versus involuntary. Beyond that, does Chapter 633 really distinguish any difference between the two once they're established?
Once they're established, I don't believe that there is a distinction within the code, but I think the fact that a ward had the ability to request such a guardianship and conservatorship be put in place has an effect on their testamentary capacity.
But if they have to, if either one wanted to terminate the guardianship conservatorship, the procedure would be the same, whether it was voluntary or involuntary, correct?
That's correct, Your Honor. They would have to request the court do that.
Let me just ask a question. It does seem that the statute doesn't directly answer the question of when the determination is made as to whether the ward has testamentary capacity. Why not, Ms. Briley makes the point, why not decide it now when you've got the witnesses, you've got the evidence, instead of having one of these cases where you know what'll happen, the lawyer will walk in and say, the person was as, sharp as a tack, and then the other side will have their witnesses and say something different, and nobody really knows what the truth is because we're talking about something that happened years ago.
I think that under that scenario, Your Honor, you run the risk of wasting essentially the court's time over and over and over again. So if we want to look back at 1992 and 2015, well, what if Mr. Radda wants to do a will in 2021, which I believe was asked? Then do we have to return again to have that will looked at over and over and over again? And I think that that's definitely a risk that would that we would run by allowing a party to question these wills during the testator's lifetime.
In guardianships and conservatorships, they're hearings that people are in and out of court all the time anyway. I mean, what's the big deal?
I think that there's a different situation in a hearing for a guardianship and conservatorship, just a run-of-the-mill hearing, versus having to bring in a jury and run through everything that would be involved with a will contest.
Assuming there would be a jury.
Assuming that there would be a jury.
Again, the statute's silent, right?
That particular statute is silent, correct?
So the probate code in other places gives interested parties specific rights, but not in this provision. Does that suggest the legislature did not intend for pre-death challenges to wills?
Absolutely, I would agree, Your Honor. I think the fact that the probate code section 6, chapter 633 frequently mentions interested parties and then doesn't in this particular code section indicates that the legislature intended to omit interested parties from being able to bring up this issue.
What are the advantages of waiting until death and the will being probated to contest the validity at that time versus what the Keeneys are proposing?
I think at that point, it essentially gives a starting point. So what was the most recent will? Let's look at that one. If by chance that will is determined to be invalid, then you can go back. But I don't know at this point to have to go back over and over again during Mr. Radda's lifetime when he could do a new will at any time in theory. I think that's...
If we allowed the procedure while Mr. Radda is still alive, is there a risk that interested parties would not be represented in such a proceeding?
I think that's absolutely a risk that we would take. I mean, yes, at this point, the Keeneys have brought this. No other potentially interested parties have been brought in. We don't know at this stage whether they're even aware of this litigation. I think that that's absolutely a risk.
Counsel, is there any issue here with the confidentiality of someone's decisions about their property after they die? I mean, with respect to my will currently, I don't have to disclose it to anybody. Is there any issue with requiring someone to disclose during their lifetime all of the contents of their will and having all of that displayed in some court matter before they pass?
Thank you for that question, Your Honor. I absolutely agree that there is an issue there. And on top of that, a will doesn't even become valid until the testator has passed away. And so in theory, what we're doing here is looking at wills that aren't valid. They serve no purpose until the person has died.
So if you're correct in that regard, then does that mean the district court erred in concluding the deck action could proceed to determine present testamentary capacity? It seems like it's all or nothing, right? I mean, either they're standing to challenge the prior wills and his current state, or it's all advisory opinion, not ripe, and the action should end. Is that correct?
Well, to look back at this, this originated from a pre-answer motion to dismiss filed by the conservator, essentially raising that issue. That motion was denied, and then we filed a motion to enlarge the ruling to clarify that issue. I think that essentially what the district court order enlarging that ruling did was look at the statute that we're dealing with, the 633, 637, and do what is allowed under that statute, which is to determine present capacity. I don't know that that present capacity matters unless Mr. Radda wants to execute a new will at this time.
How is the bank entitled to force the Keeneys to pay the bank's attorney's fees? I don't see a statute that allows for fee shifting.
You're correct, Your Honor. There is not a specific statute that allows for fee shifting. However, fee shifting has been allowed for public policy reasons. So if we play this out, the bank is getting paid by Mr. Radda. So anything in this scenario where the bank pays out money, Mr. Radda is actually paying for that. So in this case, Mr. Radda has not brought this matter. He has not participated. He's not asking for it to proceed, and yet he's being asked to pay for it. There's a reason that in a will contest, for example, those fees come out of the estate. But while Mr. Radda is still alive, he requires the use of those funds. It's doing him, in my opinion, a great disservice to ask him to pay for this when he has not requested it, doesn't necessarily even want it to proceed. So I would say that's sort of the public policy exception that would allow for fee shifting in this matter.
I mean, it seems like that reasoning could apply in any case, and yet we have this time-honored American rule that each side bears their own attorney's fees. I mean, nobody wants to be sued, and so, but that doesn't mean the court says, well, you didn't want to be sued, so the person, in order for the person to sue you, they have to pay your costs of defending yourself. Do you have any case on point?
I don't have one that's specifically this scenario, but there is a case that was mentioned in our brief, and I apologize, I'll get the title very quickly.
Eperdine or that?
That's correct, yes, and I'm sorry, did you?
Well, I mean, it just seems like that's in a different context. It's in prenup in a marital dissolution case where Chapter 598 does allow the court acting in equity to make one party pay the other's fees. Does that translate over to here?
Well, I think it does in a way, because in that case, the thought process was that you didn't want to take away from essentially what I would call a protected party, the children in that matter, and have them lose out by having funds paid out by one of their parents. In this case, you have a protected party. I think the focus on the protected party is very important here. Also, Iowa Code Section 633-551, subsection 5, specifically talks about costs in a guardianship and conservatorship. It specifically focuses on establishing a guardianship and conservatorship and who should pay those fees. There's no mention of the situation like we have here. And so if we want to go back to what's omitted, what the legislature intended, I don't think that by laying out in that code section what should be split between the parties, I don't think it forecloses the possibility that there could be fee shifting in this matter.
Given the procedural posture of the case, what's our standard of review? What we apply for rulings on motions to dismiss, or what we use for declaratory judgments since there was the expanded ruling?
An excellent question. Our position is that it should be the standard that's used for a motion to dismiss, since we're actually here on just an order enlarging the ruling on the motion to dismiss.
What's the best analytical path towards the result you seek? Is it a ruling that the Keeneys lack standing, or is there another way to just say that 633.637 doesn't allow a pre-death, or it doesn't allow what they want to do? Maybe it's the same.
I think
same
it could
thing.
go either way, and I do think there's overlap there. Probably the easiest way is a ruling that 633, 637 doesn't allow what they're wanting to do, and then essentially I would argue that there's no reason to proceed with a determination of present capacity. Just briefly, if we get to the issue of the present capacity, I would like to just touch on that briefly. Petitioners have argued that they're not contesting the actual wills, but instead asking for a determination whether Mr. Radda had capacity to execute those 1992 and 2015 wills. It seems to me that there's sort of a legal gymnastics going on there in order to potentially force this case to fall within 633, 637. No matter how petitioners phrase their request, they're questioning the validity of the wills. There wouldn't be any reason to have an issue of, or have a determination of capacity, specifically in 1992 and 2015, if not for the purpose of having those wills declared void. Also briefly, petitioners have likened the matter to in re Guardianship and Conservatorship of Henkin, which is worth mentioning is an unpublished Court of Appeals decision. But if anything, that case supports the conservator's position in this matter. In that case, there was a ward who petitioned the district court for termination of her guardianship and conservatorship and the right to draft a new will. In other words, Henkin involved the ward asking the court to determine her present testamentary capacity. I think, if anything, that's what should be allowed in this matter. Also worth mentioning is Springer, which we talked about previously, which I think is actually the controlling case on that issue. So just, I would just ask on behalf of the conservator that the district court's order enlarging the ruling be affirmed.
Thank you.
Thank you.
Ms. Briley? I have a practical question while you're getting situated.
Yes, ma'am.
If we do what you're asking us to do, I'm imagining, first of all, would you agree with me that it's pretty much common knowledge within the legal arena that just because somebody is a ward of a guardianship or conservatorship doesn't mean they can't typically create a will as long as they have testamentary capacity? That those are two different standards, correct?
Absolutely.
Okay. So if that's the case, would you also agree with me there's a lot of those out there?
Possibly. It's hard to know.
Okay,
exactly.
and if we do what you're asking us to do, then upon the death of anyone who's a ward, if they created a will, all of those are subject to a challenge.
Correct. All of those wills would be subject to challenge anyway.
Outside, well,
outside
that's
of
true
this.
anyway, but I'm saying even the challenge right now before they die, based on your recommendation.
That is true. And that does seem like an extreme result, but it is our position that if that result obtains, it is because it is necessary to comply with the requirements of the probate code. I mean, a very important point here.
But before you get to that, though,
Okay.
if that were really what the legislature wanted, aren't they pretty good about telling us the steps how to do stuff? If you're supposed to challenge it, you got to give notice, that they would probably have laid out a procedure to do this if it really was to be done beforehand.
Yes, the legislature is ordinarily very good at that. I did exhaustive searches for, in an attempt to determine what the legislative history regarding this provision is, why it was worded the way it was, found nothing. I was not able to find any legislative history on this. Possibly that is in, a written document that if I went to the appropriate building, I might be able to find, but it is not available online, so it was not possible to determine what underlay the legislature's decision to word this provision the way it did. But I think that does tie into this very important point that the conservators' argument raised, which is, was it, in fact, Mr. Radda's decision to execute either the 1992 or the 2015 will? Absent a determination that he has testamentary capacity, we can never know that. And it is very important to focus on the protected person's interest and to protect that interest. That is the entire public policy behind the establishment of guardianships and conservatorships in the first instance.
I'm intrigued by this notion that, the terms of these wills are confidential right now. I mean, are you saying you could end up having one of these testamentary capacity determinations, and then at the end of the day, it might turn out that the will would have been favorable to your clients?
Possibly, yes, absolutely. I mean, that is entirely possible.
Well, that does seem like a waste of resources. I mean, to have a whole to go through a whole challenge, and then at the end of the day, it turns out it's something that everybody in the family would have been okay with.
Absolutely. And, in such a circumstance, certainly the conservator has access to the terms of the will. The conservator was present when the will, or paid for at least, the drafting of each of these wills. The guardian has access to the terms of the will. If the terms were favorable, one would expect that the guardian and conservator could present that, whether it required disclosing all the provisions of the will or not. When my clients made inquiry about the terms of the will, they were told that that would not be disclosed, but that the will had been deposited with the court. The court is not at liberty to release the will, absent the consent of, in this case, the guardian and conservator, presumably, in conference with.
Wouldn't it probably not be too far-fetched to imagine one of these, I'll call it a cat fight. There's a family cat fight going on. Somebody's challenging this, that. There's going to be, people are going to be on both sides of the courtroom, taking sides. And regardless, let's say the outcome is the person did have testamentary capacity. And let's say that one person was going to benefit. Isn't it pretty reasonable to assume there's very much a likelihood the will's getting changed again? It's going to keep changing, especially when people tick each other off. And I mean, isn't this just opening up Pandora's box for not only extra litigation up front, but potentially more litigation down the road?
Well, it possibly it is opening a Pandora's box of litigation up front and or down the road. But the fact of the matter is that a protected person must be protected. And that is why that person's testamentary capacity must be determined before he or she makes a will.
Counsel, what is your position on the district court's current disposition on leaving the case open to determine current testamentary capacity?
As a general matter, the Keeneys are not opposed to that as a general determination, but we don't know whether.
In your petition, or somewhere in your papers, I thought that I had seen that that your clients were not interested in a current evaluation.
That is not what my clients are asking for, because it is not their understanding that Mr. Radda has asked to make a new will. They are not asking the court to determine whether, if Mr. Radda wanted to make a new will now, he has the capacity to do so. They want to ensure that when the previous wills were made, he had the capacity to make those. Thank you, Your Honors, and for these reasons, we request that the court reverse the district court's ruling.
Thank you. The case of the guardianship and conservatorship of Mr. Radda is hereby submitted, as well as the case of Luigi's versus United Fire and Casualty without oral argument. All three cases are hereby submitted, and the court is taking a recess. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.